on the record, good afternoon. This is State versus Jennifer Coombs, indictment 22-01-158, as well as 22-12-1609. If I can have the appearances of the counsel, please.
Good afternoon, Your Honor. Assistant Prosecutor Williams on for the state.
Good afternoon, Judge Anna Mitchell, on behalf of Ms. Coombs, she's present in court.
Good afternoon, counsel. Ms. Coombs, good afternoon to you.
Good afternoon to you too, sir.
Thank you. So we are here today. I've had a brief conference with counsel for a period of time. It was my understanding there were discussions as far as potential resolutions back and forth where there was close to a resolution. But at the moment, it's not there, and I think there's a request for a little more time for discussions. But Mr. Sono,
Thank you, Your Honor. Your Honor, I have been in discussion with defense counsel about possible resolutions to these matters. The state's original plea offer was plea to the fourth-degree stalking in the first indictment on this matter. That would carry with it a permanent stalking restraining order, and that would be the case by statute. The defendant to go forward with the trial on that matter or convicted on that matter. It carries a permanent stalking restraining order. The state, through this whole process, has been candid that is the main goal that the state is seeking in terms of resolution of these matters. That the main concern for the state to this victim is to prevent contact between the defendant and the victim moving forward. That's been the concern to the point that the state's plea offer throughout these many months since the defendant was first detained on this matter back in last September would have been for a time-served sentence as of the date of the plea. The only condition the state was looking for was agreement to that permanent stalking restraining order. But speaking to defense counsel, and my understanding is that the defendant was prepared to plead guilty to a stalking charge, to that stalking indictment. So the state is trying to discuss alternative possibilities. We discussed the possibility of, in lieu of the stalking restraining order, agreeing to some form of consent, no contact order, which would accomplish the same goal and prevent contact moving forward without the need for the defendant to plead guilty to the stalking charge. So that's been discussed with defense counsel. We've discussed different drafts and forms that order may take, and alternative charges the defendant to plead guilty to. The other charge that the defendant is currently charged with is contempt of a pretrial release order. So the state has proposed the defendant plead guilty to that instead, and combined with this no contact order that may create a favorable resolution for all parties. But it's my understanding that the defendant is not agreeing to that at this point, is considering it, is continuing to discuss that with her attorney in the different forms and drafts this order may take, a form that may have good implications once an opportunity to explore that further. So the state has no objection to an adjournment of this matter, a short turnaround, because we are trying to move this case forward one way or another, but we are prepared to continue engaging the defense on it. It's possible to resolve this case short of a trial, and if not, then the state would be prepared to move forward on litigating a motion that was filed by the defendant with regards to discovery and continue to litigate the case from there. But at this point, again, we would not object to more time for the defense to consider this resolution and to discuss or raise any concerns with the state. And that's the status of the case at this time. Thank you.
Mr. Mitchell.
Thanks, Judge. Just my understanding as well. I did have a conference with Your Honor and the prosecutor earlier today. We did speak about possible resolutions for the case. I'm confident that if Ms. Coombs wishes to accept the plea offer, we can get these two indictable cases down to one disorderly person's defense and a consent order for no contact. If she does not wish that, she's by no means obligated to take any of that. We are fully prepared to move forward with motion practice and ultimately trial. This is Ms. Coombs' decision to make, knowingly, voluntarily, and intelligently. And with my advice, that's all I can give her. So with that, Judge, I would submit that if we just have some time to think over the weekend, she can come back to me with whatever she wants to do on Tuesday of next week. And I'm fine with it either way, Judge. I'm perfectly happy to try the case and perfectly happy to help her reach a resolution.
Okay, sir. I certainly want to give that time. There have been extensive discussions from what I understand. Ms. Coombs, I know you wanted to say something. I'll give you just one moment. I just want to make sure that I fully understand where things are. And I will stand corrected, obviously. So there are the two cases, the two charges. One for stalking, that being the first case, and the second being for the contempt. The contempt stemming from a violation of a no victim contact order that was issued as far as pretrial release conditions on the first case being stalking. If I understand correctly, the offer being for the defendant to plead guilty on the contempt, and in exchange, as part of that, the stalking case would be dismissed. The primary desire on the part of the state, which is on behalf of the victim, is to make sure that there would be no contact between him and Ms. Coombs in the future, hence the order, that consent order that was suggested and being discussed. And now also, so that I fully understand, because the victim is a police officer. So my understanding is that any no contact would be, or I should say, would not include if he's acting in a police officer or official capacity. Because I know Ms. Coombs, she's a citizen journalist. Obviously, there's certain circumstances where she has the First Amendment right, and she wanted to carve that out. If I'm correct, am I correct so far on that?
Your Honor, we've discussed language in the order to try to address that concern, and the state's primary concern is to prevent, obviously, contact with the victim as a civilian, which is the underlying allegations in this case, and to prevent any future harassment of him and his family. But we would try to address, with regards to the order, language which would carve out if the defendant were to encounter him on the job, active duty as a law enforcement officer. So the order that we drafted and proposed and discussed and attempted to carve out that exception.
And that's, I just want to make sure, that's how I understood it, being the charge involves the victim in a private, not as private capacity or citizen capacity, not as an officer, and certainly don't want to make sure that there's no, or that the law enforcement official capacity wouldn't be part of no victim contact, because obviously that wouldn't, in regular circumstances. And then also, obviously, as a citizen journalist, Ms. Coombs, maybe at public events such as a council meeting, maybe a sporting event, where the public in general, they happen to be in the same spot, not Ms. Coombs seeking him out, or he just happens to show up somewhere where she is at those public events. I understand there were also discussions to create or ensure Ms. Coombs would still be able to go to public events to do what it is that she does, and if he just happened to be there in his private capacity, there would be language to ensure Ms. Coombs would still be able to be there, but just some keeping distance between them and not focusing attention on him, just focusing the attention for the reasons that she would be there in the first place. And the meeting, the event, things along those lines. Am I correct on that?
That's correct, Your Honor. That concern was raised by the defense as well. So we've attempted to continue to draft language and amend language to clarify, to ensure that the defendant understands exactly what the parameters of the order are. The specific prohibition the state is seeking is about maintaining a visual or physical proximity, having oral, written, electronic, or other form of communication with the victim. So when we talk about maintaining a visual or physical proximity, we attempted to draft some language that would clarify if she encountered the victim out in a public event, that's not a violation of the order per se, that keeping distance from the victim, not engaging him, not going up and getting close to him, making contact, that's what the order is concerned with, but not necessarily you encounter this person out at a public event and now you're in violation of this order. So we attempted to draft language in the order itself that would address that concern and clarify that. The state's not looking to add gotcha elements to this order. We're trying to create a situation where the victim can have peace of mind and knowing moving forward that he's not going to be subjected to harassing contact from the defendant.
So essentially, not trying to stop Ms. Coombs from doing what she normally does, and just wanted to, not as you say, no gotcha type language, not trying to set her up for failure, so that she can continue to do what she does, and including going to public events, reporting as she would a citizen journalist. But if the victim just happens to be there, making sure that there's some distance between them and the journalism isn't focused on him. Unless, hey, if he's there and he's up speaking at an event, or he becomes part of the program, I presume that would be a different scenario, because then he is the focal point. If he's up speaking at a council meeting that she happened to be at, he's putting himself in that situation. I'm presuming the state wouldn't think that would be a violation.
No, of course not, Your Honor. In that situation that's being described, the victim would be making a public presentation, at that point becoming a part of public events. So that's not what this order is designed to prevent. Designed to prevent the victim in his private civilian capacity from certainly being subject to harassment, but also following visual proximity, filming, or communications, direct communications from this defendant. That's what the order is designed to prevent, not somebody becoming a part of a public event, and this defendant happens to be there covering the public event.
And that's what I thought. I just wanted to make sure. Okay. So I do want to give that short period of time. Obviously, Ms. Coombs will want to pressure you, or one second, I'm going to hear you. I always do it, so I won't do something different this time. But we don't want to force you or pressure you, or you to feel pressured or making any decision. I want to give you that time so you can think about everything before. So whatever it is, this is your case. Whatever decision you decide, that's the way it'll go. Now, I always tell you I don't want to talk about the specifics of the case.
And this is not about specifics of the case. I don't need any more time. I'm innocent, and I'm willing to take this to trial to clear my name.
Because I can see you're getting visibly upset. No one here wants to get you upset whatsoever. There's some tissues for Ms. Coombs. Thank you. So here's we're going to be coming back Tuesday. I don't want you to say anything further because I can tell you're emotional. I don't want you to give an emotional.
I don't mean it. I want to take this. I'm
not
sorry.
trying to be rude. I am not.
I know.
I know.
I just want to take this to trial.
We're going to be back on Tuesday.
Okay.
That's where things are. We're going to get your case resolved one way or another. It's your case, as I said. However it is that you ultimately want to go, that's the way it'll go. No one's going to pressure you on anything. No one's going to force anything on you. That's just not how things work. I certainly, though, don't want you to, whatever the decision is, don't want you to make it in an emotional state right now. Because I can tell it's obvious. And like I said, I don't want you to talk about the specifics because we're on the record. So.
This specific decision was made a long time ago. So I'm just continuing with that decision. So I'm not, yes, I'm emotional, yes, but it has nothing, this decision was made a long time ago. I just don't want you to
No, I'm not, and I know, what we've been talking about is a resolution involving, the second case, which is the contempt, not talking anything about that you would be pleading guilty to the
Either
stalking.
case, either
And
case,
so,
yeah.
I just want to make sure that's there also, so we'll take your time. We'll come back on Tuesday, because we're already after hours, we can't get anything done, and anything we would have to do, no matter what scenario, is going to take time. We don't have the time, because it could take a half hour, it could take an hour, regardless of whatever course we're going to take, and certainly don't want to rush anyone. So we're going to come back on Tuesday,
Yes.
okay? And between now and Tuesday, I know Mr. Mitchell will talk with you, I know Mr. Mitchell will speak with Mr. Zone, and we'll see where things are at that point, okay, ma'am?
Thank you, sir, and I appreciate it.
What time, gentlemen, are you free? You said, Mr. Joyce said 1:30, is that what you said? Or were you available in the morning? I just want to make sure.
Should be available in the morning as well. I do.
Nine?
That's fine.
So we, that one. All right, thank you very much.
Thank you, sir. Have a good weekend.
Have a good-